I want to introduce Andrew Bossary, a senior associate attorney at Joshi Attorneys and Counselors. For over a decade, Mr. Bossary's practice is focused on parental alienation and high-conflict divorce matters. He will present the applicability of parental alienation to international child abduction cases.
Thank you very much. As was mentioned, my name is Andrew Bossary, and I'm going to talk a little bit about the Hague Convention and how PA parental alienation can apply. As was mentioned previously, the Hague Convention on the Civil Aspects of International Child Abduction is an international treaty designed to secure the return of children abducted into a foreign jurisdiction and have them returned back to their home base. What's interesting here and makes PA a little bit of an outlier is that the Hague Convention is really designed to determine jurisdiction or venue of a case. The convention itself does not have anything or really very, very little to do with custody or parenting time decisions, these issues where parental alienation comes into play. At most, the Hague courts can facilitate or enter orders to return children to one jurisdiction or the other. In some cases done early on in a case or after a hearing or trial. Here in the US, Hague cases are handled in the federal court system. And so that's a little bit of a blessing in disguise in that when you petition one of these courts for a return of a child, the judges typically don't have the in-depth experience, familiarity and practical hands-on understanding of handling high conflict divorce cases. That's not typically within their day-to-day docket. On the other hand, you get a lot of the benefits of the federal court system. We have highly qualified judges and the timelines are typically much, much more expedient. And we heard about it earlier this afternoon, the delay in between hearing and order or hearing and discovery and the final order can take months and years. In Hague cases, that's a very, very different thing. Cases take weeks to months to facilitate that. Now, when you're addressing a Hague case, what the court looks at is really what is the home jurisdiction of a child? Where is that child firmly established? And that's the court that should be deciding matters. And so these cases can come up in a wide variety of circumstances. In PA cases, generally speaking, we can have a target parent leaving a jurisdiction for one reason or another, for family support, for financial needs, what have you, and they leave with the child. We have the alienated parent filing a petition for the return of that child. Or we have an alienated parent leaving with the child and we get into a battle of, the target parent wanted to get them back to wherever they were. And so when that happens, again, the courts typically don't look at custody factors or best interest factors, which is, a lot of the things that apply when making these custody decisions. Parental alienation is something that we ask the courts to look at when determining custody and parenting time. So how does that apply in a Hague case? And I think the prior presentations really illustrate how. When you're looking at a Hague case, there's some, even if a child is supposed to return to a jurisdiction, they make the finding that a child should be in the alienator's jurisdiction. That's their quote unquote home base. There are exceptions to that rule. And one of those is the grave risk of harm defense. And what that says is even if a parent has the right to jurisdiction in a certain country and the child technically should be returned to that country, the court can issue an order that says, no, the child will not be returned, because if that happens, there is a grave risk of emotional or physical or mental harm to that child. And so we're going to keep the child where we're at. And that's a very, very practical thing in alienation cases. As was talked about at length earlier, we have serious risks of harm that can happen with alienating parents. We also have serious risks of harm that can happen to the child, short of actual physical violence. We have all the mental and emotional health concerns that rise up. We have the anxiety, the aggression, the severe mental health disorders. These are all things that courts, particularly federal courts, can be made to take notice of and enter, change the jurisdiction of a case based on them. The issue that we have in federal courts, much like in a lot of state courts, is PA is a difficult thing to convince a trial court judge of. There's the whole counterintuitive nature of it, the need for sufficient proofs and evidence. And just like we have to demonstrate everything fully and completely at the state court level, we have to do that at the federal court level. And we are sort of up against the clock at that point as well. Because like I mentioned earlier, we don't have months and years to conduct discovery or get our experts lined up, take our depositions, things of that nature. We're on a schedule of weeks to months, and that's something that federal courts do enforce. But it is an option, and it's a viable option that should and can and should be taken advantage of when applicable. Again, though, I'm not inventing the wheel here. People have tried this. Litigants have tried this, and it's difficult. There are grave risk of harm defenses reversed, or not granted, for a variety of reasons. The number ones are lack of sufficient evidence or lack of evidence of harm. And at least in my practice, what I see when I come into cases and learn about a case and get to know a parent is that the facts have been there. They've just not been presented well, or they've not been presented with a qualified and proper expert, or we don't have our documents and our exhibits lined up to make those findings. So when you're sort of pressed with this issue, if you're dealing with an international case on, the Hague, as in a Hague proceeding, and you think that the grave risk of harm defense is going to apply, you need to be able to do that legwork up front very quickly. And a couple of things that you need to do is you need to get a very qualified expert witness to present that. Federal courts can put a great deal of weight and reliability on a qualified expert who is able to present things clearly and sustain cross-examination. And the evidence is there to show that parental alienation, when filtered through that lens of a qualified expert, can rise to the level of serious physical, emotional abuse, or risk of harm. I mean, we've seen it today. There also needs to be a very concentrated effort on streamlining and gathering your discovery and documents. Clients are going to have to be put to work because you have to sort of filter an entire custody case, a custody dispute that can take years to litigate, into a presentation that can be put together in a couple of weeks to months. And you have to do that in conjunction with an expert to work on that with you and present that. That's a tall order. You need to familiarize yourself with the family court case, the local family court or domestic case. Oftentimes these cases don't come out of the blue. There's an underlying domestic case, and there are local, state, or centrally located attorneys that are far more familiar with the facts of the case. Even if your Hague practice does not necessarily involve a lot of domestic litigation, you need to consult and talk with those attorneys, and they can provide a lot of valuable insight and information to really shortcut and get you to where you need to go in terms of preparing and presenting your case. So, in the totality, even though the Hague does focus on jurisdiction, you can take elements of parental alienation and apply it to your case. When you do so, though, you have to be very conscious of how you do it. It has to be meticulous, and it has to be thoroughly prepared and really presented in a way that boils it down for a fact finder that does not have a lot of domestic court experience. If you're able to do that, then there's a possibility of overcoming that presumption that the child goes back to their home jurisdiction. There's the possibility of keeping them in a more safe and secure environment while family court proceedings carry out for determining parenting time or custody. So I think that provides just a generalized overview of how this plays into international divorce or international disputes. If there are any questions or comments on this issue, I saved a couple of minutes for that if anyone has anything on that nature.
Now it went on.
Oh,
Thank you.
I can hear you
Hi.
now.
Okay, great. So, the last 3 years, he had brought the girls to Singapore to see their stepmother. I have not agreed each time when he did that because he refused to provide contact information, itinerary information. But he went on and did that anyways. So thankfully, I see them, a month later. And this time is different. So he had my 16-year-old told me that she really want to move out of country, that I should understand because I moved out here when I was 16. And she's trying to say, no, I haven't talked to dad yet because dad always support me, but you never do. And so that is a big decision. I need to talk to your dad. But dad hasn't really wanting to communicate with me. But let me think about it. And he's waiting on me to give them a green light to say, yes, they can go on vacation. But I am extremely worried it is not a vacation. So I got to stick with, no, I do not want you to take them this time because you continually do not follow the decree term that we do not have equal amount spent with the girls every time you do that. And then again, I will not agree with you not providing these informations.
So one of the things that you mentioned there really touches on one of the aspects of the invocability or enforceability of the convention. The convention does not only apply when a parent more or less kidnaps a child or leaves without warning. The convention can also apply when a parent keeps a child longer than an agreed upon time. And so it sounds like what you're saying, that provision could come into play for some sort of protection. That being said, there are very fixed timeframes or time windows to file a petition under the convention. And if you miss those, you are in a very difficult position in trying to come out from behind that. And so if you're thinking about allowing for international visitation in this type of circumstance, one of the things you're going to have to do is be very specific on expectations. If you can convert those expectations into some type of stipulated order or agreement in a domestic case, or at least have something formally written up, that could provide some type of protection in the event the father decides or attempts to take your daughter and hold her longer. The other issue you need to be aware of is age of the children matters in convention cases. And the court does look at where a child acclimates, where they feel at home. And if this retention period, if you allow for visitation long enough for an older child to say, okay, this is my home now. I live with dad here. This is my sort of home base. That has a significant impact. So you need to be aware of those things.
16 and 12.
More so the 16-year-old than the 12-year-old by far.
Right. Well, both of them will go. So you're saying 16-year-old probably have their own rights at this time, or what?
Not their own rights. I'm saying if you're going to agree to it, you need to be very specific in terms of planning out what the limitations of the visitation are.
Thank you.
Okay. Yep. go
Just
ahead.
a reminder, this is, of course, is not official legal advice. This is all general. He doesn't know. Yeah.
That is absolutely true. This is generalized advice, not giving specific advice to any particular case. One of the questions is, why is custodial interference not being reported and enforced? The Hague application process takes way too long. Well, yes and no. You should, report custodial interference to your domestic or state court proceedings. There's no reason not to. While the Hague stays custody determinations, it does not stay enforcement. So if there's contempt proceedings or things you can do at a state court level, there's no reason not to at least make the attempt. In terms of timing, the Hague application and petition process can be very expedited. I think it was earlier this year, I had a case that was filed in November, and the trial court judge really went through a docket and got his trial dates in January. So you have to push and enforce it, but the trial courts can, or excuse me, the Hague courts, the federal courts can really put that on an expedited track. There was also a question is, why aren't parents referred to, for filing criminal? Well, my experience in this case is both parents at this point maintain custodial rights. And a lot of law enforcement agencies simply say, that's an issue for your family court. It's not they just don't want to pursue parental kidnapping issues. So it's more of a practical reality of the situation. Thank you.